My name is Joseph McDaniel, and I'm an Arizona bankruptcy attorney, and since 2005, I get to tell you that I'm a debt relief agency, and I help people and businesses file for bankruptcy. Today's bankruptcy observation is the following. Your property in Canada is not exempt, immune, or invisible if you file a bankruptcy in Arizona. Sometimes people hate the message, and often they get cranky with me when they hear what they don't want to hear. And I am apparently a glutton for punishment because I'm going to keep telling people what they don't want to hear, just as I have for the last 30 years or so. See, the statute that defines property of the estate is located at 11 U.S.C. Section 541. It was designed by the drafters of the Bankruptcy Code to pick up everything that the debtor owns in any way, shape, manner, or form, including, for instance, mining claims on the planet Neptune. If you want to read the statute in its undiluted form, go to the Cornell site and look up 11 U.S.C. Section 541. However, for ordinary people who have not been dipped in the magical protective coatings dispensed by law schools, reading statutes in their naked forms can be confusing, disorienting, scary, and confounding. Kind of like letting somebody without a divinity degree read Revelations. But here's what you need to take away from this discussion today. Do not expect a lawyer to tell you that if you own real property, which is land, dirt, building, treehouse, in Canada, or real property in Mexico, or real property in Costa Rica, that you will not need to list that real property in your chapter whatever bankruptcy in the United States, or that you'll be able to keep it without paying for it. Let me put it another way. You've got to list it in your bankruptcy. Now, there are several possible outcomes that could make you happy. One is that you list the property and the panel trustee who was appointed in your case doesn't want to bother with it because she's too busy and it's too much trouble for the apparent value of the dirt. That could happen. Don't count on it, but it could happen. A trustee is supposed to use the business judgment test to determine how best to deal with assets in a bankruptcy case, and they are seldom second-guessed. On the other hand, sometimes a decent result would be that you could buy the property back from the bankruptcy trustee at an auction held by the trustee, which auctions happen all the time. And about half the time or more, the debtor who plugs in the first lowball bid walks away with the property, no matter whether it's a replica lightsaber with gold fittings valued at $4,723.93, or a piece of undeveloped land in Barcelona, Spain, valued at $16,345.92. Now, here's a test to see whether you are sitting with a good bankruptcy lawyer in Arizona, or wherever you may be talking to a bankruptcy lawyer. If the bankruptcy lawyer you're talking to says that you don't need to list real property that you own, which is situated in Pakistan, they are not the best bankruptcy lawyer for you to be talking to. Such advice will put you in stripes, not pinstripes, not chalk stripes, sort of pajama stripes. Get the message? And while I may sound relaxed about this, hey, I plan to sound relaxed when I'm telling Doc to crack my chest and give me another stent. I most certainly am not relaxed on this topic. Think about it. If you're going to get rid of $1 million in debt, which is not all that unusual in Arizona these days, you really probably will pay a price. One of the most important prices you will pay is full disclosure on your schedules. Back when the new code and my ticket to practice law were brand new, there was a lot of weight given to the excuses. I didn't understand. I was sick when I was filling out my schedules. I was dead at the time. There is no sense of humor in the Arizona Bankruptcy Court these days in connection with failing to list a significant asset. And the U.S. Trustee's Office, a division of the U.S. Attorney's Office, has a zero-tolerance policy and is at all times looking for poster children. So, if an instant bankruptcy expert who was practicing personal injury last week tells you that you don't need to list an asset, ask him what he knows about 11 U.S.C. Section 541. Ask specifically with the numbers of the statute. It'll be interesting to see if his head does that trick from the movie The Exorcist. It's not uncommon for an experienced, capable bankruptcy attorney to discuss the sale of a non-exempt asset and the use of the proceeds for living expenses and the purchase or paydown of a lien on exempt assets. The legislative history of the new code said that without more, the conversion of non-exempt assets to exempt assets on the eve of filing was not fraudulent as to creditors. And that sounds simple. In fact, there is a phrase that has some currency in the case law, which is pigs get fat, hogs get slaughtered in connection with pre-bankruptcy planning. And of course, in any area where lawyers work, nothing is simple. And whether you are scraping off $20 million in debt or $20,000 in debt, there is always risk in any bankruptcy filing. Thank you very much.